Welcome back to the Deep Dive. Today we're tackling a really fascinating tension right at the heart of criminal law. It's this idea of legal justification. Specifically, we're asking the question, when does breaking the law actually become the socially desirable and, therefore legally protected action?
That tension is exactly why this area is so compelling. We're going to do a rigorous deep dive into the model penal code's approach here. It's the necessity defense, but officially it's known as the choice of evils defense, which is codified in Section 3.02. So our mission, it's twofold. First, we're going to meticulously dissect the four elements you have to meet for justification under subsection 1. And second, we need to understand the huge limitation that comes in with subsection 2. It often defeats the defense based on the actor's own fault.
I love that framing. So we're not just reading rules, we're trying to understand the philosophical hurdles a defendant has to clear.
Oh.
So let's start at the very foundation. What is the fundamental principle that justifies conduct that would, otherwise be a crime?
The underlying policy is really one of societal gain. The law permits conduct if, by the defendant's actions, they avoid a net loss to society. It's a utilitarian calculus. The general rule outlined in MPC Section 3.021 states that conduct is justifiable if the actor believes it's necessary to avoid a harm or evil to themselves or someone else. But, and this is key, that's provided certain objective conditions are met about the relative severity of those evils.
Okay, so that belief in necessity is central, but the law requires more than just good intentions. Can you lay out the four distinct objective hurdles, the components that make up the complete defense?
Certainly. To succeed with the choice of evil's defense, you have to establish these four components sequentially. First, necessary conduct belief. The actor has to believe the conduct is truly necessary to prevent the harm. Second, greater harm avoided. The harm or evil you avoid has to be greater than the harm caused by what you did. This is the central lesser evil part. Third is no specific exception. Neither the code itself nor any other law gives a specific out for this kind of situation. And fourth, no legislative exclusion. A clear legislative purpose to exclude this specific defense for this conduct can't plainly appear, so the legislature can't have already decided this exact conflict.
That distinction between 3 and 4, no specific exception versus no legislative exclusion, that often trips people up, doesn't it? Don't they basically just mean the legislature hasn't said no? What's the practical difference?
That's where the real insight is. The third component, no specific exception, that usually relates directly to the statute that defines the crime itself. For example, a statute against using force might have a clear exception for self-defense. So if the law already spells out how to handle the conflict, Section 3.02 is preempted.
Okay, so it's about the specific crimes definition.
Exactly. Now, the fourth component, no legislative exclusion, that's much broader. It's asking if the legislature made a policy choice somewhere else that would be overridden by allowing the defense here. For instance, let's say the legislature passed a clear law saying all private property owners must defend their property against any intrusion, even in an emergency. Well, that overriding policy choice might exclude the defense, even if the trespass law itself didn't say anything. It's all about preventing defendants and, courts from second-guessing big state policy choices.
Understood. It's a check against subverting clear legislative intent. Now that we have that robust framework, let's test it. We'll use a classic necessity problem we're calling the cliff climber. First, what are the legally dispositive facts?
Right, so the scenario is this. We have a hiker stranded high up on a steep cliff face. A storm suddenly develops, vicious winds, freezing temperatures. There's an immediate risk of death from exposure. The hiker desperately needs immediate shelter. The only structure nearby is a locked, private cabin. So the hiker smashes the window to get inside, which is criminal mischief and trespass, but they survive the night.
So we have these intentional crimes, trespass, and property damage, but they're committed just to secure life-saving shelter. And what's the core legal issue this situation presents?
The precise legal question is whether the crime committed, the breaking and entering, is justified under the choice of evils defense, MPC Section 3.02, because the hiker chose the lesser of two evils.
Okay, so what rule of law did the court apply? Can you state the full black-letter rule and break it down into its testable elements for us?
The rule is MPC Section 3.02. Conduct believed necessary to avoid a harm or evil is justifiable if the avoided harm is greater and there is no legislative preclusion. And we'll test this using those four elements we just identified. 1, necessary conduct belief. 2, greater harm avoided. 3, no specific exception. And 4, no legislative exclusion.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, necessary conduct and belief?
So the sub-issue here is whether that storm was a threat so immediate and unavoidable that the criminal conduct was really the only available option. The rule demands both the actor's subjective belief of necessity and that this belief was objectively reasonable. In the cliff climber, the application is pretty straightforward. The storm was life-threatening, and the facts tell us the cabin was the only viable immediate shelter. This wasn't just convenient, it was required for survival. Conclusion: Element 1, necessary conduct, is convincingly met.
That makes perfect sense. Survival tends to meet the necessity threshold. Now, what about the second element, greater harm avoided? This feels like the core policy test. I mean, how do we quantify and compare human life against, say, property damage?
This is the most critical sub-issue. Is death from exposure a greater harm than property damage and trespass? This comparison forces the court to, well, to place values on competing interests. The application here relies on a fundamental policy consensus. The preservation of human life, almost always, both qualitatively and quantitatively, outweighs property damage. It doesn't really matter how expensive the property is.
Hang on, isn't that a massive philosophical assumption for a court to make? Have there been situations where a court hesitated to place, infinite value on life over catastrophic property loss, like saving a priceless historical archive or some highly endangered national treasure?
That is a brilliant point, and in common law necessity, courts have sometimes struggled with that. But the MPC framework, it's intentionally structured to favor life preservation when the choice is that stark, unless the legislature has pre-weighed that specific balance differently, which would violate the case. Element 4 courts are generally going to find that avoiding death is always the greater good. In the cliff climber case, the harm caused, a broken window, is clearly less than the harm avoided, which is loss of life. So, conclusion. Element 2, greater harm, is strongly met.
Excellent distinction.
Yeah.
Okay, let's move to the third element, no pre-existing statutory exceptions.
Right. So the sub-issue for element 3 is whether the statute that defines criminal mischief or trespass already had a built-in explicit exception for emergencies. The application is just a pure text check. Did the legislature foresee this exact situation and give us a codified solution? Assuming the relevant laws are silent about emergency entries for survival, the court finds no specific exception that applies here. That means the general defense is still on the table. Conclusion: Element 3 is met.
And finally, the fourth element, no plain legislative exclusion.
This sub-issue requires the court to survey the broader legislative landscape.
Right.
Has the legislature otherwise resolved this conflict of values in a way that forbids the defense here? Application-wise, we have to assume there's no overriding law that says, for example, that the integrity of private homes must be preserved at the cost of human life, or some other policy that would kill the defense. Absent that kind of conflicting law, the defense is permitted. Conclusion: Element 4 is met.
And so after analyzing all four elements of justification under MPC 3.021, what was the court's final conclusion?
The ultimate holding is that the hiker's conduct was justified. The crimes of trespass and criminal mischief, since they were committed under the duress of a greater evil, are legally excused. The hiker is therefore not liable.
Okay, here's where the law gets really complex. What if our hiker wasn't just some innocent victim of circumstance? What happens if they were partially responsible for getting into trouble in the first place? This brings us to that crucial limitation on the defense.
This takes us directly to MPC section 3.022. This subsection brings the actor's own culpability into the equation. It makes sure the defense isn't a reward for reckless behavior. The justification becomes unavailable if the actor was reckless or negligent in one of two key ways. Either in bringing about the situation that required the choice of evils, or in appraising the necessity for the conduct itself.
Let's focus on that first part. Bringing about the situation. Can you explain how this initial fault connects back to the specific crime charged?
That connection is vital. Section 3.022 specifically says the defense is defeated only if the actor's level of fault, so recklessness or negligence in causing the emergency, is enough to establish culpability for the crime they committed. If you recklessly cause the crisis, you only lose the defense for crimes that can be satisfied by a reckless mental state.
Let's test that with a more visceral hypothetical. We'll call this one the reckless hiker. This hiker ignored 3 flashing storm warnings on their phone. They drank excessively at a high-altitude lookout point, and then they got stranded way off the marked path when the storm finally hit. They wrecked the same cabin window. The charge is criminal mischief, which requires recklessness as the default mental state. Is the defense still available here?
So in the case of the reckless hiker, the hiker consciously disregarded a substantial and unjustifiable risk. The explicit storm warnings, drinking in an exposed area, they were clearly reckless in creating that emergency situation. Now, since the offense they committed, criminal mischief only requires a reckless mental state. The hiker's reckless creation of the crisis directly matches the culpability needed for the crime. So under Section 3.02, the justification defense is defeated.
That is a very clear consequence. You create the dilemma through high-level fault. You lose the defense. But you mentioned a second way to lose it: recklessness or negligence in appraising the necessity. Give us a scenario for that one.
Okay, consider the negligent appraiser. A hiker sees a dark cloud on the horizon and panics. They break the cabin window immediately, claiming necessity. But they failed to check if the cabin door was unlocked, or maybe there was a well-marked public emergency shelter just 20 yards around the bend that they neglected to see.
So the crisis itself, the storm, might have been unavoidable, but the immediate choice to commit the crime was flawed. How does that appraisal failure defeat the defense?
The fault lies in the lack of due care in assessing the alternatives. In that scenario, the defendant might have been negligent in appraising the necessity. They failed to recognize that a less harmful alternative existed, like the unlocked door or the public shelter. So if the crime charged, say, simple criminal trespass, can be satisfied by a showing of negligence in, for instance, determining whether the entry was justified, then the defense fails. If they were merely negligent in assessing their options, they lose the defense for a negligent crime, but they might still have it for a crime requiring intent or knowledge.
The lesson here seems pretty profound. A justification defense isn't just about the outcome, saving a life. It's about the legal quality of the defendant's entire journey leading up to that choice, including how carefully they evaluated their options.
Precisely. The law demands that you not only make the right choice when you're facing two evils, but that you do so without having created that terrible choice through your own failure of care.
This has been an incredibly rigorous analysis. It really shows how the MPC layers these objective justification rules with subjective culpability limitations. For our listener who needs to apply this, particularly in a structured legal setting like an exam, how should they approach an issue-spotting problem involving necessity? Give us the final diagnostic checklist.
Absolutely. When you see a potential necessity defense, you should use this 5-point filtering process. It's rooted right in Section 3.021. Spot the conflict. First, just identify a situation where the defendant broke one law that committed harm to avoid a greater harm. If there's no competing value, move on. 2, test necessity. This is the 3.02 preamble. Did the actor truly believe the action was immediately necessary? That's your subjective inquiry. 3, weigh the evils. This is 3.021. You have to perform the objective comparison. Is the avoided harm clearly greater? Focus on the hierarchy. Life over property. Severe injury over minor injury. This is the heart of it. 4, check legislative intent. That's 3.021B and C. Scan the statutes. Has the legislature already explicitly resolved this exact conflict, either by building an exception into the crime itself or by passing some overriding policy law? If not, the justification can still hold. And finally, 5, check culpability. This is 3.22. Analyze the defendant's conduct leading up to the crisis. Were they reckless or negligent in creating the crisis or in misjudging the necessity? If so, does that level of fault match the required mens rea for the specific crime charged? If it matches, the defense is unavailable.
That checklist is invaluable because it forces a structured analysis of both the action and the actor. We've established that justification is a powerful legal shield, but it requires clearing both these high objective hurdles and some very strict culpability checks.
Indeed. It's a testament to the fact that the law recognizes the limits of legislation. But this leaves us with a final provocative thought for you to consider. While the MPC clearly favors human life over property, what happens in a future where non-human interests like, say, critical infrastructure or rare environmental resources are assigned equivalent or even greater legal weight? This kind of dynamic valuation continues to push courts in historical necessity cases well outside of the current MPC constraints.
A fascinating area for future legal development. Thank you for guiding us through this deep dive into the Model Penal Code's choice of evils defense. We encourage you to keep exploring the policy implications of that critical balancing test. Until next time.